There we go. Welcome again. The topic child custody and child maintenance. What I have noticed for the last few few months is that many people are very apprehensive of approaching the maintenance courts, the children's courts, or to put it in a different way, to start legal proceedings. They are apprehensive, they are afraid of the system, they are afraid that the system might fail them. Furthermore, they do not know what to do. And of course, that goes without saying. I mean, I myself had to learn court proceedings, how the court works, how the court thinks, and every day I'm learning as I'm going along. However, what saddens me is that people are apprehensive, people are afraid of pursuing their specific legal matters, but they are also not willing to make an effort in obtaining good results in relation to the specific legal matter. For argument's sake, and for example, you might have heard this theme over the last few weeks from me. They expect to go to the maintenance court and apply for child maintenance with no documentation, with no information, and expect the maintenance court to do everything on their behalf. The maintenance court will, of course, entertain you, they will be of assistance, but your result will not be as good as the person who put a great amount of effort in his or her application. What would be an example of putting a great amount of effort in his or her application? I'll give an example. An example would be preparing documentation, obtaining slips, putting them in a logical fashion, pasting them with print onto a page on a daily basis. At the end of the day, there might be 30 slips or 30 pages with slips for the last month. Highlighting relevant items. Green highlighting might be groceries, blue might be utilities, and so on. Whatever the case may be, the party makes an effort. He intends to go to the maintenance court and claim maintenance from the other party by making as much effort as possible in order to get the relevant result. Another example would be Googling, watching these type of webinars, going on the internet, reading articles, downloading the Maintenance Act, looking at various case laws, learning on the topic of child maintenance. Go to the local library. There's many times you find law textbooks. Some of them are outdated, but still very useful on the issue concerning child maintenance and child custody and so on. They make an effort. They do that relevant research. They try to make the case as easy as possible for the maintenance court and whoever has to deal with this matter. They do not just come to court with a request. And a request that's not very well based. Well based in the sense of outlining, I require 1,000 rand maintenance, and I'm using round figures here. I require 1,000 rand maintenance, and this is what I'm basing it upon. Here is my documentation. This is how I've worked out that I require a contribution of 500 rand to host my accommodation. My rental might be 1,500 rand per month, but I require the other party to contribute 500 rand because 2/3 of the property is getting used by me. Had I not have had a minor child, I would have most probably rented accommodation of 1,000 rand. Whatever the case may be, the person goes to the maintenance court prepared with an argument, having well thought out this case. You do not have to be a lawyer. You don't have to be highly intelligent. You do not have to be smart about this. You don't have to be someone who is an accountant. Just use normal common sense, normal logic, and a will, and you want to win your case. You want to be successful in your case, and that is what you have to do. And it saddens me that many people go to the maintenance court with that apathetic approach. I'm just going to the maintenance court because the maintenance court is there to help me. They will only assist you based upon what you have. If you assume that the other party can afford the child maintenance which you are requesting, but he or she will come to the maintenance court and lie about it, say he or she does not earn a salary, then do your research. my earlier webinar with Felicity and guests, we discussed these specific topics. Go on Facebook, go through the person's profile, see what the person done for the last 6 months. Parties, people like posting on Facebook what they do. He's saying he cannot afford to pay child maintenance of amount of 500 per month, but on every picture he has a different new item of clothing. Every week he's at a different restaurant or enjoying life. If he does not have Facebook, of course he has some friends who have Facebook and they might tag him in posts and so on. Do that type of research. Go on LinkedIn, find out what this person is stipulating that he or she does, his or her past working experience and so on. If need be, speak to his employer, contact his employer and ask the employer before the time, I'm going to the maintenance court, which you are entitled to, and say, I would like to know if he has a pension fund. I would like to know how much he earns. If they don't give you that information, then they don't give you that information. That's their thing. But you are making an effort to be successful in a maintenance application. Now compare this person who's making this effort to be successful in his or her maintenance application and is building up this big dossier of data, of information. And he presents his information to the maintenance court. He presents it. I have the relevant information. The court might not agree upon his ultimate view on how much should be allocated towards a grocery bill or how much should be allocated towards the transport or the vehicle and insurance. That's fine. The court can play around with that. But you presented relevant information to the court. As opposed to you going to the court just saying, I was married to this gentleman, we divorced, he doesn't not want to pay child maintenance, I'm here now, please help me. The only help you will get basically would be to subpoena the father in. He will say he can't afford it based upon whatever information he decides to provide. What can the maintenance court do? You do not have much information. They'll make a decision based upon whatever is presented. That is not how I will deal with any aspect in my work. If I want to lose weight for argument's sake, if I want to become a better sportsman, I'll put an effort in it. And the same applies to maintenance. For myself, for example, many times I get a client with a new topic, something which I didn't deal with for a long time. I might only bill the client 50 Rand for the consultation, but I'll have to spend most probably 20 hours researching this topic again, learning it again, speak to my colleagues about it, just in order to be able to properly consult with the client for that 50 Rand. Because I take pride in my work. The same way, if you're taking pride in your case, in your child custody case, you better do the same. We have a live question. Thank you for that. Can I see it? Yes, I can see it. The question goes as follows. Can my daughter's father force me to change my surname to his? We never lived together. We were never married. The usual question would be, yes, then the person poses the same question again. Can my daughter's father force me to change her surname from my surname to his? We were never married and never lived together. I was wondering, yes, why would the daughter's father want to change the mother's surname to his? You can't necessarily force someone to change the surname. That's the decision of the Director General. If both parties are guardianships and so on for the minor child, an application will have to be made to the Department of Home Affairs for the minor child's surname change. Both parents have to apply. If only one parent apply, the Department of Home Affairs will not change the surname unless there are other reasons. They might say, can't get hold of the other party, I don't know who the other party is, I don't know who the father is, and so on. But in normal circumstances, if the child is registered with a surname A, that's a child's surname. If you want to change the surname, the child can change the surname when he or she is older. Alternatively, the parents can apply both to have the surname of the minor child changed at the Department of Home Affairs. If one parent wants the surname to be changed and the other parent does not want it to be the case, you need to obtain the consent of the High Court. The court will have to decide whether or not it will be in the child's best interest to have the other party's surname. If the court decides that, based upon your motivation and based upon what the other party has to say, the court says, I've listened to all the facts and I am of the view it would be best for the minor child to have the surname of the mother or the father, its surname change. Then the court will make an order. The court can't order the surname change. Remember that. The court can't tell the Department of Home Affairs to change the surname. What the court can do is say, the court can say that the other parent who is refusing the application for the surname change, he or her consent on the application form for the surname change is not required. So basically, you sign as the mom, for argument's sake, if you want the surname to be changed, and you attach a court order stipulating that the father's consent is not required. And then the Director General will look at the relevant documentation, the reasons why you want to change the surname, and of course the consent of both parents are here. Technically, the High Court consented on behalf of the other party, and then the Director General will decide whether or not it's good enough reasons for a surname change. What would be a good reason? A good reason would be, for argument's sake, let's say the mother has a surname, or the child doesn't have the mother's surname, and it causes problems. The father is not really involved in the child's life. The father is nowhere to be seen. He's only involved in the child's life now and again. And when the child travels, or when the child goes to school, they always ask, why is your surname A, but your mommy's surname is B? And it causes issues. Under those circumstances, it could make sense that the minor child's surname be changed to the mother's surname. Let's say the parties were married to each other and they divorced, the mother went back to a maiden surname under those circumstances. It all depends on the facts of the case and the relevant scenario. I hope that answers your question. So technically, the court will have to decide what's best for the minor child. The other party can't force it. The other party can't tell you, you better change the surname. You can refuse. I do not want to change the surname, because you think there are no good reasons for that. And that person will take you to court, and the court will now have to decide. But I would not advise the matter to go to court. It's basically the matter gets mediated, because you do not want to fight these type of matters out in a court of law. Thank you for that. I have another question. It goes as follows. Received a lawyer's letter from my ex for maintenance, as he is paying school fees and medical aid, and change in the parenting plan. We have 50-50 custody. Let me get more information. See more. Read it. We have 50-50 custody with a one-day swap and sleep over in the week. Should I rather approach the family advocate? The family advocate's office does not necessarily deal with these type of matters, what you're talking about here. I do not necessarily see what the question is or the issue involved over here. Received a lawyer's letter from my ex for maintenance, as he is paying school fees and medical aid. So the party wants to maybe claim maintenance from the one party, and now the question is, should I approach a family advocate? I don't think the family advocate will deal in maintenance matters. That is a matter that must be resolved in the maintenance court. I would say let the maintenance court resolve the matter. My view on child maintenance is, you cannot, if the parties cannot mediate and agree upon it, then the matter must go to the maintenance court. And it's important that it goes to the maintenance court for the sole reason parties need to unpack and expose their financial situation to the maintenance court. The maintenance court is a creature of statute. It is the organization or the functionary that deals with maintenance court. It's a court specifically created for the purpose of dealing with maintenance. Therefore, the office of the family advocate is not, their purpose is not to decide and to get the parties to agree on maintenance issues. They deal more with care and custody contacts, where the child should reside, how much contact the other party should have, and so on. Therefore, to the specific question, thank you for your question, but I would advise you, please don't approach the children's court. The maintenance court is a court that must be approached. Oh, then the question goes further. He wants to cut out the one-day swap. So obviously there is now an issue regarding care and contact. Now, as I mentioned early on, what is best for the child must be decided. It's difficult for me to say what is fair and what is not fair based upon a paragraph, and then I make a decision, sucking my thumb, which I'm basically doing. And then once this matter actually gets heard and gets argued, there's a million more facts that applied. Ultimately, you must decide what is best for the minor child. If you are convinced that this one-day swap or the swap is not in the child's best interest, you need to converse that with the other party. You need to discuss it with the other party. If you guys can't come to an agreement, the matter will have to go to a third party. either to a mediator facilitator. If it cannot be resolved there, it needs to go to a court to ultimately decide on these type of matters. So, looking at a specific question, if it is a dispute regarding maintenance, the other party must decide, am I going to give more maintenance? Am I not going to give more maintenance? If I want to claim more maintenance and the other party is not willing to give me the maintenance, you need to approach a maintenance court, full stop. If there is an issue regarding care and contact, the parties can't agree upon how to share the minor child, 1 week off, 1 week on, and so on, then the matter must be mediated, try to resolve it out of court. If it cannot be resolved out of court, it needs to go to a court and a judge will make a final decision. I have an additional question. Please explain the procedure of maintenance court. You go to court, fill in a form. Do you also need to go with the police to serve the papers on the defendant? Or does the court make contact with the defendant? The maintenance court procedures are quite simple to start. Obviously, many people will complain that the courts are busy, you have to wait long in queues and so on. I don't comment upon that. There are many maintenance courts in South Africa, and many of them are good, many of them are not so good in the sense of service delivery, but that's that. You complete a maintenance application form. It's available on the internet, a Form A. Whereon you outline who you are, who the other party is, your assets, your income, how much you want, and all the expenditure for yourself and the minor children. That's the application form. It needs to be issued at the maintenance court by the maintenance clerk. They appoint a reference number or case number. So the complaint has been made. You're the complainant because you're complaining for non-compliance or for the other parties for the other party not paying maintenance, and the other party is the respondent, not the defendant. Defendant applies usually in civil matters and accused in criminal matters. That's it. So you made your application, you attach the relevant forms and so on, you leave the maintenance court. What the maintenance court then will do is, you do not go to the police. That's what one of the comments were. The maintenance court will subpoena or send a notice to the other party for him to appear in the maintenance court. So there's no obligation upon you to ensure that the other party attends the maintenance hearing. What basically happens is the maintenance court will receive 50 applications for that specific day. They will now look at the diaries. Okay, these 50 applications we're setting down for that specific day of the year. Maybe the turnaround time is 2 months, 1 month, 3 months, whatever it is, they will allocate it. They will prepare the necessary documents, the necessary directives, the necessary subpoenas or notices. They will give it to the sheriff's office or whoever is now in charge of serving this upon the other party, and that specific party will obviously do their job and serve it on the other party. And on you as well, you will get notice as well. It seems to me the maintenance courts are also now making use of emails as well. We receive notice of the maintenance court date, the maintenance court hearing date, before a maintenance officer. Both of you will come to the maintenance court and the matter gets heard and hopefully ultimately finalized. So I hope that answers your question. No police going with you. The maintenance court will serve the necessary documentation on the other party. All that you need to do is make sure, as I mentioned earlier on, you have full proof of all your income, your expenditure. You do not have to have everything. Remember that. The maintenance hearing might only be in a few weeks' time, but at least you have some documentation to assist the maintenance court in starting the process. That the bare minimum you will know of is how much does the child cost and how much you earn. If you do not know how much you earn at the start of this proceedings, you will not. How can you start with this proceedings, and how will you know that amount at the hearing of this matter? If you do not know how much the child costs, how can you stipulate an amount for maintenance from the other party? Therefore, you need to go to court prepared. A well filled in maintenance application form is extremely useful for the sole reason it's signed under oath. We all know that. We have to swear. And at the maintenance hearing, the court will be in a very good position to determine, based upon the maintenance application form, how much the child cost and how much your income is, what is your expenses, and so on. But at the same time, if the maintenance application form is not properly completed, let's say you stipulate that the grocery bill for the minor child is 2,000 rand per month. But it comes about at the maintenance inquiry, the formal inquiry before a magistrate or the judge, but the magistrate in the magistrate's court, that you were incorrect in stipulating that the grocery bill or the grocery expenses for the minor child is 2,000 rand per month. Why is there a mistake over there? Were you lying to the maintenance court? Were you trying to inflate the amounts? Why is there a discrepancy? Because in the maintenance hearing 3 months later, under cross-examination, it's clear the minor child costs 1,000 rand per month, but in the documentation you stipulate it costs 3,000 rand per month. Obviously, there's a problem. But that should not be a problem, because we all know after watching this video, you will make sure that you complete your maintenance application form correctly and as best as possible. I see no further question. I see the one commenter. Oh, yes, she says, thank you. You are welcome for that. If you have any additional questions or questions to add on to the questions that were already posed based upon my responses, please feel free to pose them. Type it in Facebook Live, the Advocate Muhammad Abduroaf Facebook page. Another commenter said, now, thank you very much. You are welcome. I spoke earlier on about taking ownership of your maintenance case. But the topic of this webinar is child custody and child maintenance. How do you take ownership of your child custody case? That's a very important question, and one which I hope I'll be able to answer. One way of doing so is to have a dossier. We all know child custody matters are about problems spouses have, or partners have, ex-lovers and so on have, regarding child, regarding the relationship and so on. Start typing. Start typing. Start from the word go. I met the father of my child on high school. That's fine. We got engaged on that year. That's fine. There were no problems in our relationship. That's fine. He lived at his mom. I lived at my place. We lived together, whatever the case may be. Then we got married. Now we need to start adding on additional information. We got married in 2020 or 2010. Things in the marriage was okay. I worked, he worked. We're adding on. I fell pregnant. Okay, here we start. Now we start adding on a lot of information. I fell pregnant. I was involved in the pregnancy, or the father was not involved in the pregnancy. These were the facts of the matter. I started working. The minor child got born. Very important point. I was at the birth. I was not at the birth. The father changed the nappies. He didn't change the nappies. I changed the nappies. I was working all the time. Child was breastfed. Child was on formula. Here you need to start providing relevant information. Now you start. Problems in the marriage. Problems in the relationship. Many times people do not get married, and we're dealing with relationships. Half my files are like that. You need to now explain to the court the issues involved, or at least some historical information. Relevant historical information would be the other party was not involved in the child's life, or was involved in the child's life. The other party was working all the time, because going forward, going to 2021, there's problems. And those specific problems, or the facts that assist us in resolving the problems today, happened many years ago. For argument's sake, if today the parties broke up, they no longer want to be together, but they have a minor child together. An important aspect in deciding on who should have primary care, with who the minor child should live from a Monday to a Friday, for argument's sake, and spend a weekend or every second weekend the other party, would be who cared for the minor child during the relationship. That's important. If the father was the one who changed the child's nappies, who fed the child, who medicated the child while his mother was working most of the time, which is normal. And now the parties separated, and this has been the case for the last 5 years. Clearly, the father must have primary care because the mother will be traveling the world every single day. She'll be working all the time. She does not have time for this, and she does not have the experience to care for the minor child as opposed to the dad. The question is here, who will better be able to care for the minor child? Either the mom, either the dad. I'm using the example of mom and dad, or more in favor of the dad for this specific webinar. Is people don't like hearing that, but I need to explain to you that the courts do not prefer one parent over the other. Of course, if the child is breastfeeding and so on, the child must be with the mom. But with modern times, things are different. Going back to 2021, I need to assess. The client is in front of me. I need to assess. Is there a case for him to have primary care? And that will be based upon historical data. Has he cared for the child? Was he, involved in the child's life? Can the child communicate with him? And so on. So those are important things to note. So we are going to, as I mentioned earlier on, regarding child maintenance, take ownership of the case. The same way regarding child custody, start typing. When you meet with your lawyer, your attorney, your advocate, whoever it is, start drafting and start consulting with you. You can provide him or her with a very detailed outline of your life. He or she might not want all of that data, but you can easily answer those questions. It often happens when I'm consulting with clients can't tell me a lot of information, a lot of relevant information that would assist me in my case. They cannot provide it to me. Cannot provide it to me. And they're speaking about times when there were problems, when there were issues, maybe a few months ago, maybe a few years ago. They should have documented it, because at that time already they saw problems happening. That is how you can take ownership over your child custody case. If you have any questions, please feel free to pose it. I prefer to answer questions as opposed to just speaking about my own experiences and my own clients. It's very beneficial if somebody can learn from a legal professional who answers a question based solely upon your specific scenario. How else can I take ownership of a child custody case? There are many other ways. One way is to consult. Consult with a social worker. Consult with a psychologist. Meet with a psychologist. Like psychologist, you can advise a psychologist. These are the issues in my marriage. These are the problems I have. What do you recommend? What should I do? You have done something about it. You are learning. You are educating yourself. Maybe have a legal advice consultation with a lawyer. This will, at the early stages when the problems are arising, to educate yourself, to prepare yourself. These are important things you need to do. But the most important thing that you need to do is you need to take ownership of your problem. Record things. It's very important. It becomes very useful. If you never use it, wonderful. If you are watching this video, obviously there are issues involved because it relates to you. Start recording now. Of course, you would not know that you should record 5-10 years ago. I'm certain you know that information will remember. Hold on to WhatsApp messages, because WhatsApp messages can provide a lot of data, a lot of insight about what happened historically, happened in the past. Emails and so on. I have another live question. Thank you for that. Let me get to it. Okay, it goes as follows. We are currently getting divorced. Kids came to me every Wednesday and second weekend since we separated. So that's about 4, 5, 6 days a month. So they separated in August. And now she served papers and is moving the kids to Worcester. Is this allowed? And she leaving me out of school decisions, etc. What are my rights? Also, she left her provident fund off the form and worried she spent it already as she left her job. These are the real life issues that people have to deal with, and which I'm here, hopefully I can assist you on. So the parties are involved in the divorce. The father is seeing the child now every second weekend and on a Wednesday, on every Wednesday. They separated since August, and now she served divorce papers on him. And she intends to move to Worcester. And the question is this allowed? It's a very difficult thing to answer. Firstly, the parties need to discuss it. number one. But if they discuss it and they can't come to an agreement, what happens then? I do not know the reasons why the mother wants to go to Worcester. It might be very good reasons, it might be bad reasons. And the challenge would be, if the mother does go to Worcester, when does the father have contact with the minor children? Must he drive down to Worcester every second weekend to collect them? These are the issues that needs to be resolved. It's difficult for me to say the mother was incorrect to do so. I hope she did consult with you. If she did not consult with you, please try to consult with her regarding this and try to convince her. If you believe it is not in the minor children's best interest to go to Worcester, then you are basically saying the mother should remain in Cape Town. Is she going for work? Is she going for something else? We do not know. I do not know that. But I do not have to know it for this purposes. It won't help much. A mother leaving to Worcester with the minor children, as opposed to her going to Worcester alone and leaving the kids at home. Can the father care for the kids? Is he capable of caring for the kids? Why must they remain in Cape Town? Is it only because of the father or because of their schooling, their education, and family and so on? Those are important questions to be made. No, the mother needs to consult with you. But what if she doesn't consult with you? Does it mean automatically the default is she must stay behind? Who makes the final decision? That is my question to you. The mother sits down with you. She says, I want to go to Worcester. For whatever reasons, you say no. Does it mean she must stay? These are difficult questions. If the mother has very good reasons to go, and the minor kids needs to go with her, Worcester is a different area. You can't force somebody to stay in the area where they're residing. Of course, you can stop the person maybe from going to a different province because they fix the minor kids, but it's a different discussion. Of course, going to a different country. You need to discuss it with her. If you guys can't come to an agreement and she still goes, you need to approach the court. The court needs to stop it. The court needs to say the minor children should stay here. But if you are saying the kids must stay with you, obviously you need to be able to convince the court that you can care for the kids just as well as the mother. And it's better for the kids, for the mother to go to Worcester alone, and for the kids to stay in Cape Town with you or wherever you are. It will be better for them as opposed to going to Worcester. I can care for the kids better than the mother can care for the kids. Regarding the Provident Fund, the Provident Fund, I presume the married income is a property and forms part of the joint estate. You need to contact the Provident Fund and find out what's happening. Has she used the Provident Fund? Is she using the money? Has the money been paid out or not? Because the money belongs to the joint estate. If she did not mention it in the divorce paperwork, you can of course mention it in a counter application, in a counter claim. And you can mention the Provident Fund must be paid out. Your half of the Provident Fund must be paid out to you within 90 days, whatever the case may be, whatever the law currently says. Keep on changing the dates. 6 months, 90 days, I do not know. 6 months or 90 days, I do not know. But be that as it may, you have a right to approach a Provident Fund and ask them that question, especially now that the matter is pending before court, or speak to her about it and find out exactly what the answers are. I hope that answers that question. I'm trying to be as general as possible, but I think the take home would be speak, communicate, consult, and if they do not respond correctly, you have additional options available. Try to mediate maybe, and if you need to, especially regarding the aspect regarding the kids, you need to go to court. On the Provident Fund, if you use up the money, it was part of the joint estate, was it allowed? I do not know. What did you use it for? Because if you use it to build a part of the house, and then I'm using a different example here, if you use a part of the Provident Fund to build a part of the house, automatically that part of the house becomes part of the Provident Fund. Those are important questions which you need to ask and find out answers for. I have an additional live question. In maintenance, bundles can become a lot of paperwork. What is the best to put into it? My current bundle is over 700 pages and counting. I would say, I know 700 pages is a lot of pages. What I would not want to do is to advise here in isolation what needs to be there and what not needs to be there. You need to put stuff or documentation into your bundle to prove your case, to prove your finances, to prove that you are incurring so much money per month, so much expenses per month, that you are earning so much money per month, and so on. If it is relevant to your case, attach it because it's proof. The bare minimum you should have, I would say, would be at least 6 months of income and expenditure. I would say 6 months, not 3 months, as some people would prefer. And depending upon your case, maybe longer also if you have access to that. It depends on the circumstances and the facts of the matter. Therefore, if it's relevant, put it in there. If it's not relevant, do not put it in there. But the other party also has an opportunity to ask you for that. And maybe that should happen. You should send the other party a request. I require the following information and documentation from you, and they should do the same. And you provide it, and you guys exchange it accordingly. So relevant is different to every case. What might be relevant in one case might not be relevant in another case. Okay, I hope that answers that specific question. We have another live question. Thank you for bringing these questions to my PC. The person has an add-on question. The lawyer's letter states that if I don't agree to the demands, they will approach the family court. That's standard. They're allowed to do that. Also, they say I must give him half medical aid and half school fees. So he must pay half the medical and half the school. Can I say I will take over school fees and medical aid payments? Okay, regarding the need to go to court, they're welcome to do that. I think that's standard. Lawyers type it out. They just do that. Yes, you can say I will take over the school fees, but if you guys can't agree, you're welcome to ask. That's where I'm going to. You can ask if the other party agrees. Wonderful, great. But if the other party does not agree, then the court will have to decide. That's my motto. I prepare cases for my clients. I present cases. If you agree with me, if the other side agrees with me, wonderful. We settle the matter. We leave the court to do. If we cannot agree, they have full right to do that. The same way, they don't have to agree with what I have to propose. Let the court ultimately decide. Try to, but don't necessarily take that attitude too early in the game. Present to them. When you say you'd like to take over the school fees and medical aid payments, explain why. Put it on pen and paper. Explain the financial situation to them. The very least, should this matter go to court, you can show the court you did try to resolve this matter. You are welcome. Somebody commented now. Thank you. I have about 2 or 3 minutes left for any further questions. Otherwise, I will be online Monday coming. Is that the 1st of February? The time is flying. I'll be online again in the morning. I do not want to specifically stipulate what time. It's either 9:30, 9:30, or 10. If you are interested in watching that webinar, please like the Advocate Mohammed Abduroaf Facebook page. On that page, we advertise or we notify people when the next webinar will take place. We're also planning on having live Zoom webinars whereby you can register for the webinar, Zoom, and be part of the conversation, whereby I'll basically cater for your questions first. So you register, you get an email, you get a Zoom link, and then we're there, and then we have the discussion. It also plays onto Facebook, but Facebook will be secondary for that. It seems to me the Zoom webinars are a bit more effective, more efficient, because you can pose a question before the time. So we will be having that as well. So please, if you want to partake in our future webinars or see the notifications for the next webinars, the Advocate Mohammed Abduroaf Facebook page. And at the same time, if you see this video, you watch this video on YouTube later on, or later on the Our Lawyer page and other pages, please note, I do not get access to those pages. I can only look at one screen, and that's the Advocate Mohammed Abduroaf Facebook page. I hope you enjoyed this webinar. Thank you for partaking. To all of you posing those questions, thank you for doing so. I hope you have a wonderful weekend, and I'll see you again in February 2021.